Good morning, all. We're here for a hearing today for an immediate judgment application hearing in the matter of CFI 023-2017 before His Excellency Justice Shamlan Sawalehi. The claimant is represented by Ahmed bin Dahi, law firm. Lead counsel is Ahmed bin Dahi, assisting is Muhammad Nabawi. The defendant is represented by Damac Properties. Lead counsel is Christopher Burke, assisting is Ramon Farag.
This is the application of the defendant to strike out the particular claim and issue the immediate judgment. So I went through the application and skeleton argument filed by the defendant. My understanding that the claimant did not file skeleton argument. This is right?
Can I speak?
Please,
Okay.
just to clarify my understanding.
Okay. We submitted our claim, to cancel. We submitted our claim to cancel the SPA dated 24 November 2009.
Straight and right. There is something called skeleton argument. In this court proceeding, there is something called skeleton argument, which is both sides has to submit it to the court before they come before the hearing.
Yeah.
So that particular document was not submitted by your side, was submitted by the other side. Just want to make sure that this is the fact.
Yeah.
We'll come to your argument and your position later on. But this type of argument, this type of document is not being submitted, which is required by both parties.
We submitted before on the first.
No. You submit claim form and you submit particular claim, but you didn't submit something called a skeleton argument.
Ah.
Right. Anyway, just to make this on the record, I will ask the applicant, the defendant, to make your statement and go through your position. They will come back to you, right? Because we're dealing now with the application, not with the actual claim.
Yeah.
Application to strike out and to issue immediate judgment. Please.
Your Excellency, as you pointed out, the application before the court today is submitted for a strikeout of the particulars of claim and also for the court to issue immediate judgment against the claimant. So by its application on the 11th of April, the defendant applicant submitted its application before the court. As Your Excellency pointed out, we submitted the skeleton argument last week with the application bundle. I assume, looking that the application bundle has been received by the court. In essence, the claim revolves around a sale and purchase agreement which is dated 24 November 2009. The purchase price for the unit, as stated in the sale and purchase agreement, if I could take the court into the application bundle to page 21 of the application bundle, where you have the particulars of sale set out there.
Yes.
So item 3 on that page, it describes the unit as DFO/2A/215A, and the total area there is described as 89.09 square metres.
Yes.
So that, as I pointed out, that was signed in 2009. And then in 2014, the claimant took possession of that unit. That, in essence, is where the claim found is on the unit and the SPA.
On which side?
Sorry,
That the claimant took that position of the unit with which size? Size of the unit?
the size of the unit, we say was what is described in the SPA. I'll come to that as I go through the application, Your Excellency. So this application is to strike out particulars of claim pursuant to Rule 4.16 and for the court to issue immediate judgment under Rule 4.12, Subrule 12, and 24.1, Subrule 8. We also seek costs and legal fees of the case. The basis for the application is that there is no reasonable prospects of success, and that the pleadings as submitted to the court are wholly obscure, embarrassing, and ought to be struck out by the court. There is no evidence that has been submitted to date to support the allegations that have been made, and to the point, even if evidence was to be produced at some point in the future, whatever that may be, the relief that is sought by the applicant, or the claimant I might say, is not available under the court or the SPA to be awarded. Insofar as the applicant can say, if I can take the court to the statement of case, which is page 12 under tab 3 of the application bundle. Yes. The particulars of claim are effectively a one-page document. There's no pleadings of fact, there's no pleadings of basis of the case. It, in essence, says that on the second page, that is page 15 of the application bundle, the claimant somehow, that the claimant discovered that the size of the unit has been changed from 89.09 square metres to 62 square metres without the knowledge of the claimant or his approval, and that the unit is no longer suitable for the purpose purchased by the claimant for it. There is no details as to what or how the claimant may have discovered, what was the claimant's state of mind, what is his purpose for purchasing the unit. We just have bald, grand assertions of no meaning. As it currently stands, those particulars of claim, you cannot plead to them, you cannot plead a defence. The claimant has also sought in his relief at item 1 for the court to cancel the SPA dated 24 November, and then 2, to obligate the defendant, that is Damac, to pay the claimant the amount of US $600,178 in addition to interest. As we will set out, that relief is not available to the claimant even if he wants to be wholly successful. If I can take Your Excellency to paragraph 4.4 of the skeleton arguments.
Yes.
And I won't read through it unless you wish me to, Your Excellency, but there we have a basic understanding of the requirements for pleadings, so that effectively in the DIFC courts, as any common law courts, we play with our hand face up. There's no surprises. You should know the case that you have to know the case that you have to plead to, and you have to know the case that you need to defend. On these current pleadings, the defendant has no idea what the case is that it needs to defend. If I can then move through to point 5 of the skeleton argument, and this is where I will take Your Excellency through the SPA, which begins, as I said, on page 21 of the application bundle. And it is for these reasons that I will take Your Excellency through that the applicant defendant says that there is no reasonable prospects of success in this case for the claimant, and that this is the quintessential case where a summary judgment or strikeout, immediate judgment ought to be given. As I've mentioned prior, the area described in the particulars was a total area of 89.89 square metres. If I can then ask the court to turn to page 24 of the SPA.
Yes.
And the third definition down is a definition of common office area. That is defined as that part of the common property located on any particular floor in the building which has only office units that is attributed only to the occupiers of the office units on that floor. Each office unit shall have a right to a share of the common office area on their particular floor on the basis of the net area of the office unit divided by the total net size of all the office units on that floor. Now, I should point out that the unit we are talking about is an office unit. It is not a residential unit that we are talking about. I then asked the court to turn over to page 36 of the application bundle. And clause 10.10. Clause 10.10 says that the purchaser acknowledges and understands that the total area of the unit, now if we go back to the particulars of the unit, is described as the total area of 89.99. So the total area of the unit, as stated in section 3 of the particulars, is the net floor area of the unit, measured from the exterior faces of the exterior walls and from the centre lines of the common walls joining two units and across internal walls. However, if the permitted use of the unit is office, then the total area of the office unit includes, for the purpose of calculation of the purchase price only, that part of the common office area which is attributable to the unit as described in clause 1.1 of this agreement. Notwithstanding the foregoing, the purchaser acknowledges and agrees that the area of the unit being sold and registered at the land registry shall be the net area in all cases subject to the applicable laws. So in essence, what that is saying is that you get the actual office area, and part of that in that calculation for the total area is an area of the common property of the office floor that you get to use as an office facility. That is the total area as described as 89.09 square metres. We then, if I can ask the court to turn to page 40 of the application bundle.
Yes.
Now, if I can take your excellency to clause 12.1. It's quite a lengthy paragraph, so please indulge me while I go through it. The seller and the master developer may from time to time make such variations to the master plan, unit plan and the project plan. Thus, while the master plan, unit plan and the project plan have been prepared and are as accurate as possible, the purchaser acknowledges that they are not yet final and adjustments to the final measurements of the unit and participation quotas may need to be made. If the final measurement of the unit is larger than the measurement represented to the purchaser in this agreement, then the purchase price for the property will be increased proportionally if the difference is more than 3%. However, no adjustment to the purchase price shall be made if the final measurement of the unit is larger and the difference is less than 3%. If the final measurement of the unit is smaller than the measurement represented to the purchaser in this agreement, then the purchase price for the property will be decreased if the difference is more than 5%. However, no adjustment to the purchase price shall be made if the final measurement of the unit is smaller and the difference is less than 5%. In this case, the purchaser will have no claim against the seller for the deficiency in the size of the unit. We then move down to 12.2, which provides that the seller is at its sole discretion entitled to change, vary or modify the design, layout or location of the unit or the drawing, which includes all architectural, structural, landscaping, grading, mechanical and other plans whatsoever, colour, materials, finishes, equipment, fixtures, specifications pertaining to the building and the number of floors, etc., etc. I then move down to clause 12.3, which says that the purchaser hereby consents to any changes, variations, modifications and substitutions and agrees to comply with his obligations contained in this agreement, notwithstanding any of the changes, variations or modifications described above. So, in the essence of what we understand the case to be, the claimant is alleging that his unit is smaller than what he says he bought. The clauses that I've just taken the court to clearly show that even if the claimant's hold is successful and could show at some future point in time that the unit was changed, the relief that is available is provided for under the contract, and that is for an adjustment in the purchase price. Yet, Damac says that there has been no change whatsoever in the unit price, and the claimant has simply misunderstood or not read the contract and calculated net versus total area as to what he actually purchased. Now, even on the figures that the claimant has put into his particulars of claim, that's exactly the figure of the net and total area. So the net unit, even on his claim, is exactly what he purchased under this agreement. There is no change. It's for that reason we say that this is a case where it is the perfect or the precise case where a summary judgment ought to be given. And it would be a waste of time and costs to proceed further when, after all that, we will get to the same result. I would say that, in concluding this, I would also refer to a previous case that was before this court in a similar instance on a similar agreement as the Hafiz case, where Justice Giles, for similar reasons and basis, struck out the claim on the basis that there was no reasonable prospects of success. The case before the court now is one that is obscure, and it is certainly one that is right to be struck out with immediate judgment granted. Unless I can assist the court further, I'll take my leave.
Thank you. Just a question before I leave you. When you hand over the unit has been handed over to the claimant.
2014 it was handed over, yes.
When you hand over the unit, was there any kind of description of the final size of the unit before any authority in the DIFC registry? Or
There is, if I may assist.
Just to compare what has been agreed to and what has been delivered?
Now, this hasn't if I can.
Yes, of course. You can. Please.
So, from the document I've just provided to my colleagues and to the court, this, I understand, is what was registered with the DIFC for the purposes of the unit, and in the top left-hand corner, it has the unit area, which is the net area, which is described, and that's 68.48 square metres.
if we compare this with the original size,
that is the net area of the unit, and then you add on what's described as the office common, the common office area, and that's where you get to the gross area of 89.09.
so what we are getting from this, the unit area is different than the common area?
The common area isn't, because you can't register common area on the title.
Yes.
That, for the purposes of the calculations under the SPA and the purchase price, you get the net area plus a share of the common area.
Which will come to 85, 89?
Comes to 89.09.
Yes.
So the net area of the office is, and always has been, 65, 68.
That the net area is described in the SPA?
No, because the area would, and it's done for the calculation of the purchase price, is only done as a total gross area of 89. It clearly says 10.10, and it's 10.10, Your Excellency, that's the key clause here.
Just let me go through again. Then, yes.
So if I can take you to the last sentence of clause 10.10,
Yes.
and this ties in with the document I've just handed up to the court. Notwithstanding the foregoing, the purchaser acknowledges and agrees that the area of the unit being sold and registered at the land registry shall be the net area, in all cases subject to the applicable laws. And that's the net area as described in the document that's just been handed over. So in addition to that, for the purposes of the purchase price and the SPA, you also get a share in the common property, and that is the total area, which equals 89.09.
And this is could not be described earlier in the SPA, exactly how much going to be the unit area or the net area? This is impossible, or?
Well, anything's possible in hindsight, Your Excellency. The way it was done was to say that you get an area and you purchase an area being the unit plus a share. So when you purchase into an office, you get to use a front desk reception area, common kitchen area. So part of that is your package when you purchase this unit. And to calculate the purchase price, we give you a division of, with all the units on that, office units on that floor, calculated against the net area that you're purchasing, that's your share. And that's how we work out, that's how the purchase price is worked out, and the gross area is worked out.
Okay, thank you.
Thank you, Your Excellency.
This is the time for the claimant to make their position and.
Yes, Your Honor. Sir, we are talking about 30% difference in the size of the unit. As they mentioned, it's the unit now it's 68.48, and in the contract it's 89 point. It's almost 20 square meter different in size. So even if it is, we are not talking about 2% or 5% as they said in the contract. It is 20%. So your honor, as we ask in our claim to cancel the SPA dated on 24 of 2009, and to claim $600,000 and 12% of the interest. And sir, that is if the size of the unit it's not clear, and even if the common area it's not mentioned properly in the contract, we can ask for an expert to take the measurement of the unit and give us the exact area of this office. And thank you very much, sir.
Yeah, just before I leave you, maybe you've heard the position of the claimant about the legal basis for your claim. You are asking the court to cancel the SPA. Now, according to the SPA and item number 12, there's a solution. Even so, if there is some kind of variation in the size, unit size, then there is a variation, there is a solution to make kind of adjustment of the payment and this kind of stuff, but not a cancellation. So, based on what you are asking the court to cancel the SPA, and this is why the applicant, being the defendant, struggle with find the basis for your claim, so then they can make their defense on that basis. If you understand my
Yes,
question.
yes, I understand, sir.
Regardless if there is some kind of change in the final size of the unit, but what you're asking the court is to cancel the contract or the SPA. So based on which legal principle, on which law you are asking the court to cancel the SPA? Take your time, consult with your friend just before you answer this question, because this is very critical.
الحين نحب خصوص الكانسليشن يعني ما في شيء كان كانسل
بس لازم يخلق
يعني بس العقد ما يقول لك يعني كانسل العقد
بس
Sir, if there is any adjustment in payment, it will be fine for us, because the difference in size, it's almost 20 meters.
Yes?
So we will take we will forget about the cancellation of the SPA dated on November 2009, and we will ask for adjustment in price.
So that means your original claim need to be changed. Because you are claiming cancellation, you are not claiming different in price, even if there is any kind of adjustment or change in the size of the unit. Is that right?
Yeah.
Thank you. You would like to reply on this side?
Your Excellency, I think on that basis, the concession that's been made from the bar table is that the case should be struck out on the basis that it's not pleaded in the alternative. If there's a concession that they're no longer going to proceed with the cancellation, I think that's the final score on the end of the matter.
So when this unit being delivered, 2014?
Yes, Your Excellency.
And today, 2000, almost
4 years ago.
So what happened?
There's been nothing in between as far as I'm aware.
So if you can just explain for me, since the claimant already received the unit in 2014, right?
Yes, yes, sir. 2014.
And today-
he got no, sir, to know the difference in size when
Took him 2 years to
yeah.
find that?
Yes, sir, because he didn't take any measurement when he hand over the office. So he get to know when Damac sent him a maintenance fees. He get to know that there is a difference in size.
Now the claimant already paid the price of the unit in advance or installment, right?
Yeah,
So there is nothing, during those 4 years, there is no any pending installment? or-
No.
So let me understand that. The claimant received the unit 2014, and is he still occupied the unit or he's renting the unit?
في
He didn't.
If you can cancel with you.
Okay. But he found the size is different.
He didn't use it, sir, until now. He didn't occupy it until now.
So why there is no any action has been made since 2014?
ليش ما خد action؟
ما
2014.
اكتشفش المساحة.
As I said, sir, he didn't know about the size until he received
Maintenance?
the maintenance fees, yeah.
The maintenance fees is every year, right? So supposed to be he received it in 2015, 16,
I don't
17.
know about it, sir, but
I'm following your logic.
yes,
I understand you take an instruction.
yeah.
But this is for the court to be in the right position to understand why the claimant being silent.
I don't know when the letter said sent from the map to him. I am not sure about it. And he offered the unit for sale. That time he know the new buyer he take the measurement, then he found there is a big difference of 30%.
So the objection came from the new buyer, not from the.
Yeah, he get to know that there is a difference in size here.
I understand. I'm looking for right position. The claimant did not object when he get the unit, and he was, let's say, okay with that for a long period of time. Then when he put it for sale, the new buyer discovered
Discover the difference.
and this is the case,
Yeah.
right? And since the claimant received the unit in 2014, he did not write to the Damac saying, look, I received the unit, but there is some kind of difference in size. There is no such of communication or objection letter or something like this. Nothing, right?
There is no ما بعد شيء حق ماكو في الفترة هذه لما عرفت عن طريقنا he sent the notice here to the mark that there is
I need to know, I need to see that notice.
when a notice. It is in the files here.
Take me now to that. There is in the file. There is in the file.
وين الانذار؟ الانذارات اللي بعثناها.
Because I believe the SPA will regulate that type of notification. Size different of any. I didn't come to that part, but I'm assuming there's kind of
موجودة عندك.
deadline for notification or that.
There is a, it hasn't been produced into the bundle, but there is a notice of discharge, which when the unit is handed over, they go around, they do an inspection of the unit, the purchaser signs that off saying the unit is handed over to me. If
But the SPA itself did not cover any item where it says that if the purchaser finds later on any problem with the unit, then within period of time he can notify the.
no, well, it's the applicant's position that once the unit's handed over and the
Yeah.
money's paid, the contract's the
I'm
pays
just
the
trying to
discharge.
find if the SPA has any kind of article.
I'm not aware of one off the top of my head.
So the discharge,
If I can take you, I can
Yes.
take the court to page 71 of the application bundle.
71. Yes. not signed.
Now, this is the form of discharge that is provided within the SPA that the purchaser signs. And now, the signed copy is not in the court today, but my understanding is that all purchasers.
Would you please send it to the register?
I can send that. We can send that through. That'll be done this afternoon, Your Excellency.
Okay. We look for a letter of discharge and
Through the
So, just to clarify this, the unit, since it's been received, was never rent or used?
Never used.
Yes. Never rent, huh?
No.
Since then, 2004.
If there was any dispute as to the quality or size, is there a provision in the SPA?
All right, I think I've done from my side. Reserve my judgment for a while. Probably after the Eid, 1 week after the Eid, I will issue my judgment in this regard. Thank you very much.
Thank you, sir.
All right.